There's a new way to impute income for child support purposes in Oklahoma. I'm Tulsa attorney James Worth. We're talking about some recent changes to the Oklahoma child support guidelines that just went into effect November 1st of 2021, and they deal with imputed income. That is, if it's a circumstance for one of the parents where it is not easy to determine what their income is or they're not working, then you can use imputed income. And when you're determining child support in Oklahoma, it goes by the Oklahoma guidelines. The most important factor in determining child support under the guidelines is going to be the party's income. You look at each parent's income, you plug those numbers in along with a couple other numbers, it spits out the amount that needs to be paid in child support. However, if based on the circumstances, it's not equitable to go with their actual earnings, maybe because they're intentionally underemployed, or maybe because they're in between jobs, or maybe because they're temporarily working at something that's not their normal type of work, or they're not working at all. In those circumstances, income is imputed. And what has changed is that there's a couple new ways under the statute, or slightly different ways under the statute, to determine imputed income. So first off, the most popular one that we see is if the parties are not working, and the presumption is under those circumstances, historically what it's been is that you would generally impute that person to at least the minimum wage for a 40-hour work week. If there's good evidence to suggest they're intentionally unemployed or underemployed, where they could be making more, then you could argue for more, but usually it's at least a 40-hour work week for minimum wage. However, what has changed under the law now, based on this new version, is that it says wages the parent could earn consistent with the minimum wage rate of not less than 25 hours per week. So normally it'd be 40 hours a week, that's full-time. However, the law now defines full-time as anywhere between 25 and 40 hours per week. So potentially that could mean that imputed income for somebody who's not working could be lowered quite a bit, 15 less hours at the minimum wage. The other provision that puts in there for imputing income is it says you could go with the average wages and hours worked in the parent's particular industry and geographic area, and the parents based on the parent's education, training, and work experience and ability to work. So this is fairly commonsensical. This is what we would normally look at for somebody who is intentionally unemployed, is what are they able to work in the workplace. The only thing is that now it's in the statute that you can look at these things, and normally we look more at this particular person's circumstances, and this suggests we take their circumstances, plug it into what the industry averages are for the geographic area to get the amounts. So that is a change in the statute that probably won't be a big change in practice, because that was normally commonly done, although it's a little more specific on how it's done there. The bigger change is that now we're looking at a potentially as low as a 25-hour work week when we're imputing to minimum wage. So if that affects your circumstances, you're probably going to want to talk to an attorney more specifically about that to get legal advice privately. If you want to talk to somebody at my office, you can go online to makelawEasy.com.